Hi, I'm attorney Sherri Stinson, your Palm Harbor estate planning attorney, and I've been helping families in Pinellas and Pasco County protect their estates, their families, and what matters to them most for over 20 years. And in today's video, I want to talk to you about a really big life transition, and this is estate planning after losing a spouse. Now, oftentimes people are going through the grieving process, and this really isn't something that is top of mind and awareness for them, but it's really, really important because oftentimes we find that when something happens to your spouse, medical issues for the surviving spouse soon follow. So, one of the things that you need to consider is how are your accounts owned? Perhaps you had joint accounts. Now, I often hear people say, well, this was a joint account with my spouse. I don't really need to do anything. Now, that's true to some extent, but you need to really take a look at beneficiary designations because oftentimes I find those joint accounts don't have those. And what that means is if you then die and you don't have those designations on there, that might be a probate asset for the ones that you leave behind. The other issue that I very commonly see is that spouses will have multiple accounts at one bank. And the problem with this is that oftentimes people will have accounts that they don't realize are in their name alone. So many times, certain banks will send master statements and it will list all those accounts on one statement. But what people don't realize is that there might be joint accounts mixed in with accounts that are owned individually. And so when the spouse dies, they find themselves needing to go through probate for one small account. Now, that can be really problematic if that account doesn't have a lot of value because your attorney's fees and your filing fees will often exceed the money that's in that account. So we know you're grieving, but this is a good time when you can collect your thoughts to stop and revisit these issues. The other thing that we find is that oftentimes people will have done estate planning documents in the past, and the only person that's named on perhaps a power of attorney or in a will as a personal representative or an executor or perhaps even a trust is the spouse. So the trust or whatever document might still be okay, but otherwise, if we don't have an additional person named, now we're going back and we're getting court involvement. And what this means is additional time and expense and frustration for the ones that you're leaving behind. So if you have questions and you don't know where to start, I want you to give our office a call. We'll be happy to talk to you. This is a common scenario that we deal with every day. Or if you're still a little bit overwhelmed and perhaps reaching out to a person feels like a little bit too much, you can also visit my website where I'll have a free estate planning checklist for you. You can download that and reach out to us in your own time. And you can also take a look at the other videos on our YouTube channel. Thank you so much for watching, and we look forward to talking to you.